respected Shri Senior Advocate Sridharan Sam, Rajiv Bhai Luthia, Bharat Bhai Semlani, President Yatin Desai, other dignitaries, ladies and gentlemen. I welcome you to this third day, this last day of this residential refresher course, and we are going to have two very interesting sessions. In the morning, I was surprised that in the breakfast there was a jalebi. So I was asking the chairman why in the morning there is a sweet. So we have a session of Sridharan sir, and the topic is also prosecution and arrest and everything. So it is better that first we lighten you and then we will listen to him, so there will be less impact on all of us. Also, yesterday some delegates were discussing the Modi government is promising we will remove all the taxes, and so next year what we will discuss if there is no service tax or anything like that. What I am suggesting is you keep the service tax, keep the rate half, but keep our professional as a collecting agent, so we receive this amount, and I am sure we will going to collect double this amount, and money comes to us. We are the main agent of the government. So let's see who comes to the power, and then we'll take it forward. Also, there are about 15 to 20 non-members who have come here. So if you have liked this program, and of course there are so many other interesting programs we had. So on behalf of Membership and Public Relation Committee, I invite them to join our fraternity. What CTC stand for is, it will give you the confidence, the training, the conviction. So I request non-members to please join us. Also members who have any other suggestions we are all welcome to it. Now I request Rajiv Bhai to introduce Mr. Sridharan sir. Thank you.
Respected dignitaries on dais, it's really a matter of proud privilege to introduce learned faculty of the day, Advocate V. Sridharan, Senior Advocate. It's a rare, a person who is practicing indirect tax has rarely not heard of the name LNS, Lakshmi Kumar and Sridharan. He is a founder member and founder partner of the LNS. He has a degree in mathematics as far as qualification is concerned, and cost accountant, chartered accountant. Apart from that, he is LLB from Delhi University. Has been dealing with various areas of practice, that is indirect taxes, service tax, VAT, customs. Apart, more important, anti-dumping and WTO law. It's really a fun and pleasure, rather I am saying it's a great learning experience if those who have watched him arguing in the legal forums, tribunals and the courts, as the case may be. And obviously listening to him on this our forum, professional forum, he's been kind enough always to support an organization like our chambers, and we are fortunate to have him today. I can speak for as much as more than 1 hour on about his introduction, but I think more important today is par excellence. He is going to take us through that par: prosecution, arrest and recovery, the speaker of the day. And it's as difficult for me to explain because you can't introduce sun. Sun will express himself or present himself by the shine and the light which he is going to give. So our Sridharan sir is going to throw light on the subject PAR. Please welcome him with a loud applause. Before Sridharan sir start his talk of the day, I will request Parimal Bhai to offer a memento as a mark of our respect. Thank you very much, sir. Sir, you want me to operate this? You want me to operate? Huh. Yeah.
Friends, I was told my session has to end at 11:15, okay? And therefore I am extremely thankful to you for saving half an hour of your own boredom, okay?
Sir, I'll just correct it. You are extended by, because there's a delay on our part on that front. Please, you carry on. You will cover the topic. Time is up to you.
You know that Limitation Act doesn't apply to special statute, so you have no power of condemnation. No, last year we read that no income tax High Court doesn't have power to condone delay in the appeals. Central Excise Act High Court doesn't have power. Then retrospective amendment came, etc. Okay. Friends, we don't want to waste time. Therefore, we'll straight away get into the core topic. Rajiv told me when he asked me to talk about these topics, I said, I would be much more useful if you ask me to discuss something about what is consideration or two-way supplies, etc. He says that those things we will read, but current topic of season is this arrest and prosecution. Okay. And therefore, he perhaps knew I am weaker in arrest and prosecution than even in the main topic, therefore he has given me the topic. I propose to split this discussion into 2-3 parts, and you all welcome to ask question at any stage you want, subject to what the leaders say. Okay. First on generally about offence in the Act and prosecution in the Service Tax Act, then arrest. That's a matter of worry, because in this country neither the Service Tax Department is interested in prosecuting you nor the court. Because once a prosecution launch, you can take 30-40 years for it to end. So there will nothing to be worried about that. Okay. The arrest is something need to be worried about. So there's a complete distinction between prosecution and arrest. Income Tax Act, for example, has a power of prosecution. They don't have power of arrest. Luckily, otherwise Inspector in Moradabad will run amok. Okay. So Sahu sir once told me that many times they proposed. The minister said nothing doing. We will not give you power of arrest. Okay. So there's a distinction between prosecution for an offence and an arrest. They need not go parallelly. Generally, if there is no prosecution for an offence, there cannot be an arrest. But there can be a prosecution with or without arrest. Okay. And our states are very ingenious. I had a case from West Bengal. The client kept on asking me, sir, there is a classification dispute. Is there a problem of arrest, etc. Then I looked up the West Bengal Value Added Tax Act. There is only power to prosecute. There is no power to arrest at all. Okay. Then that client from Excite telephoned me. Sir, what is this you have been telling me the last 2 months? Oh, the police have arrested my indirect tax chief. Okay. So I said, you have no power of arrest under the Sales Tax Act. No, sir, for cheating under IPC. And then I asked JP Ketan, who is a close friend of mine. He says, what are you talking? The state government has no money at all. Okay. And they arrested the director of Damodar Valley Corporation, which is a public sector undertaking also. So why I am saying is, while theoretically, prosecution for an offence is separate, arrest is different. Okay. Ordinarily, if you are not committed an offence and there is no prosecution possible, there will not be an arrest. Okay. So two distinct aspects we will see. If you see the sections very briefly, 189D is non-payment of amount collected towards service tax to central government beyond a period of 6 months from the date on which such payment became due. Amount exceeds rupees 50 lakhs. Okay. That is one. And it is cognizable and non-bailable. We will deal with that. What is the meaning of cognizable and non-bailable in a minute. But this can be a ground for launching criminal case against you. Non-payment of amount collected to central government beyond a period of 6 months from the due date and exceeds 50 lakhs. That is one category. Then the other three, knowingly evades payment of service tax, then avails credit without receipt of the input or capital goods, or the taxable service or excisable goods, then maintains false books of accounts or fails to supply information which is required to supply. In C, the second leg, fail to supply any information which is required to supply under the Act, under the chapter. Kindly note that whether that can be a ground for misuse by the tax authority. Okay. So, if you commit an offence which doesn't fall in either A, B, C, D, then there will never be a criminal case against you. For example, if it's a delay in payment of tax, admitted tax, you file a return, delay in paying tax, you are not collected from the customer, but delay in payment of tax, those will not be governed by it. So unless there is knowingly evades payment of tax under A, or avails credit without receiving this taxable service. So therefore, if any kind of dispute, however frivolous the claim is, on SENVAT credit, you are taken credit on something totally unavailable, then also will not be liable for prosecution if you have received their input or goods. For example, diesel is never allowed for credit, but you have taken credit on diesel also. That will be disallowed, maybe that fellow puts 100% penalty, but that will not be ground for launching cross prosecution, because B covers avails and utilizes credit without receipt of input or excisable goods, input or input service or excisable goods. So where you have received and taken the credit which is express inadmissible, you may be liable for tax, interest, penalties, etc. But that will not be ground for prosecution. And C, maintains false books of accounts or fails to supply any information which is required to supply. I don't know where they copied this from, maybe from provision in FERA or SEBI Act, etc. If you fail to supply any information which is required to supply, suppose therefore summons are issued, you don't answer the summons, attend the summons, can it be a ground? According to me, summons is to collect evidence. Okay. So therefore, this is failed to supply information which is required to supply will not be governed by this. So failure to attend to summons will not be a ground for prosecution. That will be separately dealt with under CRPC, because this will be treated as a court judicial proceedings. Failure to not attend the summons will be separately tried under that. The court may issue a bailable, non-bailable warrant to compel your presence to appear. Okay. But fails to supply information, I am told some rule requires you to mention what are the books of accounts you maintain. When I was asking Kalpesh bhai what all this could be, so you have to give a list of your stock ledger, etc. If you fail to give that, that's an information which you are required to give. Sir, for such a petty thing, can there be a prosecution like this? So I told him, look, they copied it from some act, out of context. Okay, but any case, this cannot be a ground to threaten to arrest. Okay, so three categories A, B, C. These are only for ultimately they will lodge a criminal case and the trial will go on for years together. The first one, non-payment of amount collected to a service tax beyond a period of 6 months and amount exceeding 50 lakhs, then that's liable for prosecution, also arrest. Now if you see in the right hand side of this, two columns, cognizable and bailable, non-cognizable, bailable. Okay. Most of you must be, I am not familiar with this, I just looked it up and I am just sharing what little I have learnt on it. Broadly I am told, cognizable offence is something which is more serious and grave. Okay, the police itself, police officer, the inspector himself can take action in power of arresting you, etc. Non-cognizable is less serious. One of my juniors said, I told him, sir, I always get confused between cognizable and non-cognizable. Very simple, sir. Non-serious and non-cognizable. Non-rakho. You just keep that in mind. So non-serious offence is non-cognizable. Okay. That means the police officer himself cannot take action. He has to get the warrant from the court, permission of the court, etc. So non-cognizable offence is something which the inspector or superintendent himself cannot take action. He has to go to the court, get his permission and then start. Okay. So non-cognizable is non-serious offences. Okay. cognizable offences or serious offences, relatively. There is no link between cognizable and bailable and non-cognizable and bailable. That's two different things. Okay. Therefore, the legislature itself feels evasion of payment of service tax or availing credit without receiving this input or maintaining false books of accounts, or in that sense, between the collection and non-payment and this, less serious and therefore called non-cognizable. And if you collect tax and don't remit, they view that as serious matter in indirect tax also, being in indirect tax, and therefore put it as cognizable. Therefore, the excise authority or service tax authority himself can take cognizance of your non-payment and take further action. That's the distinction between non-cognizable and cognizable. But I was told, while this is broadly the principle, there are some oddities. Possessing a knife is a cognizable offence. Causing grievous hurt by a knife is non-cognizable. My junior told me yesterday, that is, causing grievous hurt with a knife is less serious. Possessing a knife. Then one of my culprits then told me, maybe with the knife you don't know what you can do. When you actually commit it, you know you have done a non-grievous hurt. Therefore, actual offence has taken place, we are able to judge the gravity of it. But when you are at a pre-offence stage, you don't know what you are up to. So therefore, the legislature puts this as cognizable. Possessing of a knife is a cognizable offence. Causing grievous hurt is non-cognizable. Because always, that's what they say, intent evade, how will I know what you meant? The judges say, and Saucer gives that example, American Home Appliances case he gave. It's very difficult to know others' mind, but law repeatedly requires you to know what the intention is. That's a difficult task. What you intend from surrounding circumstances, facts, circumstances. So, this is the distinction between non-cognizable and cognizable. We then come to bailable and non-bailable. Ordinarily, there is no link between the two. I will take you to the text of the section also in a minute. Bailable offences means, if you offer bail, the authority arresting you is bound to grant you bail. He cannot decline, he has no discretion. Okay. So therefore, all offences in Service Tax Act are non-cognizable and bailable, except 89D, which we will deal with separately. Okay. So all offences are non-cognizable, that's one part, that's not that important. Bailable. So whosoever effects an arrest is bound to give you bail. All therefore you have to be careful is, if that people want to be nasty and say, I'll arrest you, it's bailable, but you don't have a proper surety, etc., to give bail bonds, etc., then you must have a criminal lawyer who will have standard stock persons who are in a position to give bail bonds. It's not easy, sir. One of my friends had this problem. Then I said, I will stand as a surety in the bail bond. Firstly, lawyers are prohibited under the Bar Council Code. Secondly, he will ask for a certificate of solvency of more than 1 lakh. And that can be only from Tahsildar. So how many of you have the certificate about your solvency from Tahsildar? None of us will. You can never can. So these are the tricks. So therefore, if at all, if this eventuality arises, you have to offer for bail, is bound to. And generally they are not interested also, because there is no fun in arresting you to be released then and there. Okay. But if the eventuality arises, all you must be careful is, most of them it can be your own bond. In a bailable offences, the bond can be your own. Okay. But you want to be extra careful, and you don't want to give a chance to your superintendent to harass you. So keep a lawyer who will arrange a surety for that. When you go for the statement itself, that's the only precaution we have to take. Okay. Non-bailable, aage jaye, Rajiv bhai? Yes. A non-bailable does not mean bail can't be granted. Okay. It only means the bail is at the discretion of the court. Okay. So it's at the discretion of the court. So, okay. And the court can, in a case where you collect the tax, generally they will say, we will not give you bail till the time you make the payment. If you are collected or not paid. Okay. So that's the only distinction between bailable and non-bailable. Okay. Now we'll analyze the section in some more detail just now. But all of you have the act with you, sir? As a practitioner, you must also have your eyes and ears open. The power to arrest and all is largely discretionary. Okay. So if you are practicing in a particular place like Bombay or something, you could have a rough idea which are the aggressive commissioners or assistant commissioners who would like to misuse their powers. Most of them do not, because they don't get anything in this and their headache is there. They have to go to the criminal court. But some of them are perverse, they get sadistic pleasure in it. So apart from the legal part of it, you must have a rough idea of which type of, if the investigation is done by X, then you will be a little more careful. Investigation is done by Y, you can be fair about it. In fact, one matter of bank account attachment, which I am going to discuss in about 15 minutes, was going on in the High Court. So the client told me that, sir, they want to arrest the chairman of the company. Then I told Chief Justice Mohit Shah, sir, you have been adjourning the matters, I am told they want to arrest. We will say arrest without handcuffing. Because that's what I said, it's good for TV news, sir, for the viewers, for the person is a serious matter. No, I was joking. Then he told the government counsel, what is, you people are interested in tax or what are you? No, sir, we have no intention to arrest. Because once they arrest, it cannot come before the writ court, you have to go to the criminal court, etc. They will. Okay. But therefore, in all these matters, if you apprehend and arrest, if you somehow bring the matter in a writ petition in the court, however frivolous it is, not on arrest, but on other allied issues, that is much easier to get an order. They themselves will tell the government counsel, what are you up to? So, if you are careless, then only you have to really go to the criminal court, the magistrate and apply for bail, etc. If you are a little watchful, keep an idea of which authority is doing what. Okay. We all interact with each other, the news spreads also. Okay. And somehow, if this matter is brought to the High Court in some context or other, you cannot file a writ under 226 against the arrest. Okay. They will say that the criminal matter go to the criminal court, etc. But some matter is pending. At this stage, you can conveniently mention. You generally, the writ courts in these matters, good corporations, etc., they will say, they will not pass an order, but tell the government, please take care. When the matter is pending for us, don't think you are too smart. That will work. These are two practical hints I want to tell you. It happened in one Raymond matter also. I'll take 1 minute because it's a practical lesson to all of us. Client telephoned Prakasha and said, sir, I'm told that they want to arrest me, the GM. Prakasha is a very seasoned fellow. He told him, you straight away come to my office. He came to the office. Then he told me, Prakash told me, Sridharan, every writ you draft is perfect. By the time our client will be in jail, I'm going to draft and don't show it to you, I will file it. Because if he shows to me, I will start correcting it and it will take 2 days. So he filed it. Next day morning at 11 o'clock, he told the judge, my lord, there's a great urgency. Please list the matter today itself. The judge said 3 o'clock. Lunchtime, 3 o'clock, after lunch. Then Prakash said 12 o'clock. The judge said, why? Great. My lords, 12 o'clock. He didn't tell me. And 12 o'clock matter was taken up. We told my lords, the Raymond, there's a tax dispute. What do they want? They want to arrest you. No coercive methods, either against the company or the officials. One line order was passed, 12 o'clock. I didn't realize what Prakash told me. At 12:30, we sent a letter because there was summons to him to appear. So we sent a letter saying that he cannot attend the summons today because appearing in the High Court. Because tomorrow we don't want them to use this as an excuse. You are not cooperating with us. So we formally told him at 10:30 in the morning that he cannot attend you because in the High Court. The inspector came to the High Court saying that. And I to gala pakad liya usko, you are under arrest outside the court. Then I went back and told the judge, my lords, I told him that you have granted stay and he is not believing me. He said, he is outside. Yes, you please call him. Bhagya, one said. He ran away. He said, court is calling you because I told him. Okay. So you got to be careful in this. This is not storytelling. In these matters, you must err in favor of caution. Okay. Don't take anything to chance, thinking that nothing will happen, etc. Because this happens in bureaucracy, everything happens in ad hoc manner, and there is no remedial situation. Okay. So therefore, you need to be vigilant. If I had said 3 o'clock, at 12 o'clock that fellow would come, we would have been in trouble. This is the reason why I mentioned these 3 factors is this. These are not written in the law, but from a practical experience I tell you, I will repeat it. Keep an eye on who is the investigating officer, what is his general practice. Not only the inspector, the commissioner, etc., the whole hierarchy of it, you must have an eye on it. Secondly, somehow bring up the matter in the court, in the form of writ petition, against stay, whatever it is, however frivolous it is, don't bother about it. Okay. And then you can persuade the court to this. And third, you must always be vigilant in this. Okay. Right. Now kindly come to 91. Anyone can read for me, sir? Anybody can read? Raju, aap padho na? 91. 91. Power to arrest. Section 91.
Yeah, 91 subclause 1. If the Commissioner of Central Excise has reason to believe that any person has committed an offence specified in clause small 1 or clause small Roman 2 of subsection 1 of section 89, he may be generally or special order authorizes any officer of Central Excise not below the rank of Superintendent of Central Excise to arrest such person.
Yes. So this 91(1) covers all. 89(1) and 2 is exhaustive of everything. So, and this is an eyewash. Commissioner, Chief Commissioner, Prime Minister, all of them don't apply their mind. It is not as if Inspector will not apply their mind and Commissioner is worse. Okay. So the 19(1) is an eyewash. Okay. So he can authorize a superintendent by general or special order to arrest. Okay. And 89(1) and 1(2) covers all. A, B, C, D we saw just now. All of them are A, B, C, D are the offences, 1 and 2 are the punishments. So under 91(1), the power of arrest is there for all offences. Okay. Then 91(2).
Where a person is arrested for any cognizable offence, every officer authorized to arrest a person shall inform such person of ground of arrest and produce him before a magistrate within 24 hours.
So cognizable offence we just now saw, what is more serious? Is a cognizable. Basically it will be the collected and not remitted. So 91(2). 91(3).
In the case of non-cognizable and bailable offences, the Assistant Commissioner or the Deputy Commissioner, as the case may be, shall for the purpose of releasing an arrested person on bail or otherwise have the same powers and be subject to the same provisions as an officer in charge of a police station has and is subject to under section 436 of the CPC.
So 91(3), he says non-cognizable and bailable offences. Then the excise commissioner has the power as a police officer, and that power of police under 436, if you offer bail, he is bound to accept. Okay. So that's what it is. Shall be for the purpose of releasing an arrested person on bail. Okay. So he has no discretion not to accept it. Okay. So you are bound to release you on bail. So therefore, if it is non-cognizable and bailable, if it is cognizable, which is what that 89(D) would be, collected and not paid to the government, which is what will be cognizable and non-bailable, then that will be governed by 91(2). There you will be produced before the magistrate. Otherwise, it will be governed by 91(3). The officer himself is bound to release you on bail. Then what is the meaning of cognizable and bailable? If you kindly come to 90 subsection 2, 90 subsection 91 and 91(2). 90.
Subclause 1?
Subsection 1.
An offence under clause Roman 2 of subsection 1 of section 89 shall be cognizable.
Cognizable. This is where you collect and don't remit. That will be 89(1)(2). That will be cognizable. Okay.
And
then
subclause 2 of 90. Notwithstanding anything contained in the CPC, all offences except the offences specified in subsection 1 shall be non-cognizable and bailable.
So, 90 subsection 2 makes it clear that every offence in the Service Tax Act except 89(1)(2) is non-cognizable and bailable. Non-cognizable in the sense criminal prosecution cannot be initiated without the leave of the court. That's one part, we are not really concerned with that. And bailable. So anything other than 89D, read with 89(1)(2), that is collected and not paid for more than 6 months where the amounts exceed 50 lakhs, then every other offence will be bailable and is bound release on bail. Clear no sir so far? No complication? Okay. आगे जाए? Okay.
Sir, is there any provision of anticipatory bail in this?
When anticipatory bail will not be governed by this act, that will be governed by CRPC, and in Maharashtra anticipatory bail provision is there, but there is no need for an anticipatory bail because when the offence is bailable, automatically the authority himself will release on bail. For non-bailable, non-bailable certainly you can go for anticipatory bail. There is no problem on that. Theoretically, yes. But there you have to be careful. If the non-bailable in anticipatory bail is rejected, then you are in difficulty. So you must carefully weigh. We'll come to that in a minute. So therefore, except cases of collection and not paid for beyond 6 months for about exceeding 50 lakhs, then there will be otherwise no arrest, or if the arrest is technical in nature. Okay. So that's one part of it. Now let us come back to 89(1)(d). No. Can we read 89(1)(d) only?
I'll start D clause.
D only.
Sorry. The upper line is whoever commits any of the following offence, namely knowingly evade the
सब छोड़ दीजिए, D only.
Okay. Collects any amount as service tax but fails to pay the amount so collected to the credit of central government beyond a period of 6 months from the date on which such payment becomes due, and then it shall be punishable.
हाँ वो ठीक है. So 89(1)(d) offence separately will be tried for prosecution except that may take ages, but that can be a ground for arrest and you will be brought before a magistrate. Bail has to be granted with the magistrate. Officer cannot grant. Okay. It's a discretion of him. Okay. Now 2-3 points which we want to discuss. I am not saying I am right in it. Collects any amount of service tax here refers to actual collection. Invoicing will not be collection. Under the Act post 2011, your liability to pay service tax is on accrual basis. Whether you receive payment or not. But for purpose of 89(1)(d), when section refers to collects amount of service tax, it is not referring to invoicing. There is a problem in the later part of the section beyond 6 months when it is due. That we will come to that later. What I want to emphasize is collects any service tax and does not pay to the credit of the government. Okay. You invoice the customer has not paid. Your liability to pay service tax under Rule 6 and point of taxation rules etc. might have occurred, but that will not be a ground for arrest or prosecution. Collects here means physical act of collection. Why? You are dealing with a taxing statute. You are dealing with a criminal provision in a taxing statute and has to be strictly construed. So, if you invoice the customer, this is not a section for delay in payment of tax. If you delay the payment of tax, only provision is interest. Even ABC do not apply. Okay. You don't pay the tax by the due date, that's a different matter. You are 75, 76, 78, etc. may take care. So, collects here means actual collection, not invoicing, because what Rajiv was saying is in number of cases the customers do not pay for 3 months, 6 months, etc. Okay, in security agencies, that's one point. But the counterpoint to what I said is, but fails to pay the amount collected to the credit of the central government beyond a period of 6 months from the date on which such payment becomes due. So here the later part says such payment becomes due. It becomes due the day you invoice. It becomes due day you invoice. They will wait for 6 months the day you invoice. But first part refers to collection. The answer to that is, even though the second part refers to 6 from the day it is due, first part still refers to collection. The second part is only indicating how long they will wait before prosecuting. It is how to calculate the time till which his patients will wait and beyond which his patients will wear out. So the later part of the section, within 6 months of the date payment become due. Payment might have become due on the date of invoicing. But suppose a customer has not paid you for 8 months. He has not paid for 8 months. First part of the section is not attracted. There is no collection and therefore it will not apply. That's the first point I wanted to emphasize. Sahu sir, you want to say something? नहीं आप बोलना तो बोलिए ना. Thank you. If there's an error, I don't want 100 of them to carry it. Okay. Yes, sir.
In case of the service, tax are not separately charged in the bill.
अभी आते हैं 1 minute में. Just 1 minute. I'm older and therefore slower. Okay. A good point. I'm grateful to you for asking it. If I miss it out, kindly. Okay. Second, this section was introduced from what date, sir? 2013. Okay, whatever date it is. So, in criminal law can never be, offences can never be retrospective. So, in cases you collected earlier prior to that date and not paid, even for 10 years the section will not apply. Okay. Because there is transition provision. This will not be useful 2 years later. After service tax is abolished, as requested by our president, this question may not arise. Okay.
But sir, they have applied.
No?
They have applied. In Ahmedabad, they have made two
And the magistrate also said section is not retrospective and released him also.
No, they have given just bail.
He said on the reason that section is not retrospective, is not a continuing offence, therefore
Then after second arrest also came on the same ground.
for the offence taking place after that date. For collections made after this date, this section will apply. I am only saying this is a transition provision, okay, and this will not be exhaustive of all the situations, but just want to, as I said, this point will not be relevant 2 years later. Yes, sir.
What will be the date of offence? Whether the completion of 6 months?
No, date on which you collect. Date on which you collect. That's why I said you don't delay by 10 years also. The offence is committed the day you collect and don't remit. Okay. I'll come to that in a minute. So, that 6 months is not yet over by the time amendment came, etc., not relevant for this. The offence, this section is not retrospective because no criminal provision is retrospective. Secondly, the gravamen of the offence is collection without remitting. Right. So that the offence takes place on that day. The prosecution argued that's a continuing offence. And therefore, in view of the judgment of Supreme Court Mayer and Ipunj, it will. They say continuing offence should be offence. It's an offence every day. For example, failure to file a return. Every day the delay continues. It's an offence, continuing offence. It's not an offence take place on one particular day. But at least in a case, the court, magistrate court in Ahmedabad held also. There is not a continuing offence. That's debatable. But in a case of this type, the liability to pay occurs at one particular time, namely forthwith you must pay. Okay. So therefore, it may not be a continuing offence. Okay. Even as a continuing offence, I am not sure if on the first day it occurred, the section is not applicable. On the day subsequently it continues, it can be applicable. It's a debatable point. More than one view is possible on that. Okay. That's the second. 3, that may not happen in practice, but just for completion in the discussion. If you collect it provisionally or tentatively with an liability or an intention to return to the customer, see, you don't know about the taxability. You don't know about the taxability, but you then collect it. Okay. But you tell that I'll return it. Or in your book show it's a liability account, liability to the customer. That is provisional collection with an obligation to return it back. Our Supreme Court in R.S. Joshi's case held 39 STCS. So R.S. Joshi, Ajit Sugar Mills. Ajit Sugar Mills. Collected is collected and retained as yours. Collected with a liability to return will not be collected. Okay. So many cases in the Supreme Court said The parties argued. Your section says anybody who collects it should have to pay it to the government. Otherwise I'll put penalty. Then the assessee argued this section is unconstitutional because many cases pending a dispute, I'll collect it, I'll agree to return to him. Your section says moment you collect, I'll forfeit it, I'll put penalty on you. Then Supreme Court Justice Krishna have said, we contextualize the section and follow an Australian decision saying collected here means collected and retained as yours. Collected with the liability to return. A provisional collection will not be collected. That's what Supreme Court said in R.S. Joshi. There's another judgment of Supreme Court in Mysore Spinning Mills also, sales tax, both are sales tax judgments, both are constitutional bench judgments. Saying collected with an obligation to return or a liability to return or intent to return will not be collected. Okay. Last part is what my friend asked. Collects any amount as service tax. Okay. So this section says collects any amount as service tax but fails to pay. Okay. If you collect it as part of price, he says I don't show service tax separately in the invoice. I don't know. That may be compliance with rule 4 or whatever it is, 4A. 4A. That requires you to show separately. Also your 12A of the Central Excise Act will separately require to show what is the this thing. But in a case where in your invoice doesn't show the breakup, it may be breach of 4A, but that will not amount to collection as service tax. You see, there may be breach of rule 4A. Okay, that will be a different matter. Okay, but that will not attract 18 and 1D. Collects any amount of service tax means you must tell the customer I'm collecting a service tax. You collect it as part of price, that will not be covered by this. Okay. Collects any amount as service tax. Moolchand Savai Shashi Mukherjee judgment, Moolchand Shamlal. I don't remember the citation. UP Sugarcane says some purchase tax was levied or flour mill, and collected as tax means as representing tax. So you make a lump sum price, that will not be collected as service tax. Okay. So Moolchand Shamlal. Moolchand Sahu sir? आपको मालूम है साहब.
Sir, in spite it is mentioned on the bill, it is inclusive of service tax.
Makes no difference. Inclusive, okay, you don't show the breakup, but inclusive of service tax, also no problem. 50 STC, Gujarat High Court. It only means you assure the buyer that you will not make a supplementary claim on him later. Inclusive of service tax does not mean any particular amount is included in it. For the purpose of refund and unjust enrichment, that may be different. Because there, incidence of duty is passed on, you will not get refund. Incidence of duty is passed on, you will not get refund. That language is different. Collect any amount as service tax. So there must be representation, claim as service tax. So lump sum amount collected, no.
Sir, one more variation here. I have raised the bill for 50 lakhs rupees, 12% service tax, 6 lakh 56, and client pays me on account.
Yes.
25 lakhs.
Yes.
Have I collected the service tax in the 25 or?
Okay. So sir, I was thinking chart account will come to account on account payment karke. Correct, nothing wrong in it.
So this is a practical problem because I have charged the service tax to the customer.
One ITR, let me note down this. For this time I got the citation. One ITR 94, 1993, volume 1 ITR 94. Maharaj Kumar Kameshwar Singh XC, 1933, Privy Council. First volume of ITR itself. Okay. I was about to mention this. I am extremely happy you people. No, not the preempt. The very next point. You have put it on logical straight. He also asked at the logical time only. He didn't jump the gun. That's the very next point. Very good. Okay. And sometimes I miss it out. That's it. I was telling Rajiv Bhai in the morning. Okay. In this Raja Kamakshar Singh, the Britishers, all the leading judgments and income tax straight to 50 are all only the Rajas and Maharajas. Because Britishers got hold of their main fellows and every case they decided against them. Okay. That party was a money lender. Okay. Then the customer has repaid money. Ordinarily, in commerce and business, when you repay the money to the lender, it will be adjusted against the interest. First adjust, then against the principal. Income tax department doesn't do that, no? They normally adjust against their tax. Income tax department adjusts against the tax, but if they really do it against interest, we will be in trouble. In all sales tax law sections specifically say, if the tax, interest and penalty and the amount remitted by the party is less than the sum total, we will first adjust against penalty. Penalty bachne ke baad interest, then we will adjust against principal karke, sections are there. Okay. Income tax is silent now. There is one old rule 6 or something which is deleted. I will tell you the story separately. Okay. In this Raja Kamakya Singh, the borrower paid money. Okay. This fellow deliberately adjusted against principal only. The income tax department said, if you adjust against interest, I will get income tax on interest. Okay. If I adjust against the principal sum, he doesn't get tax. Therefore, income tax department argued, ordinary way businessmen appropriate would be towards interest. Therefore, I am entitled to presume that he is adjusted against interest. Therefore, I will have income tax on that. The Privy Council rejected it. It is open to the assessee to adjust it in the matter most prejudicial to the revenue. This is the very language used. Most prejudicial to the revenue. Therefore, even in a case where you raise principal and service tax separately, customer does not, he makes an on-account payment. He does not say that adjust against this or this. Then it is open to you to adjust in any one of them. Okay. Therefore, in your accounts, if you have two liabilities, I don't know how you people account it, then you can show I have adjusted against this portion of it. The difficulty in that principal interest case and your case is, there are two different debts. One the principal sum and interest. Here when you raise it is one single debt. There are not two debts due from the customer to you. Okay. No two debts due. But then you cannot assume, minimum first thing you can say is, when against the full invoice of 50 lakhs plus 6 lakhs, 56 lakhs, he pays 35 lakhs. Revenue cannot assume that 35 lakhs first is adjusted towards 6 lakhs. Balance will be to this. That cannot be done. That Raja Kamakya Singh is very clear. Okay. Suppose he pays more than 50 lakhs, then what can he do? Suppose on-account payment is done against 2-3 invoices. Okay. Suppose he makes a payment of 52 lakhs in this. Is it open to you to adjust 50 lakhs as the first invoice and 2 lakhs as the next invoice? I am not clear on that. Clayton's rule, contract also is subject to contract to the contrary. 596061 rule in Clayton. That is when more than one debt is there, you can add, if it is not appropriated, then it will be sequential. But if you appropriate against any, is no difficulty. 596061, that this can apply to tax. Kindly also note this, that this principle of adjustment, appropriation of payment can apply to tax laws. Our Supreme Court has held in that octroi case, 83 STC, Telco. V. Ramaswamy's judgment, Justice V. Ramaswamy's judgment. Because they will say contract law, our tax law is supreme, it will override everything, as if this is the only law existing in the world. So Telco's judgment says Clayton's rule can apply. What happened in octroi? You can claim refund if the goods are within 6 months it has gone out. Okay. So easiest way to harass anybody is, please prove each nut and bolt for which a claimed refund has come back within 6 months. Telco will importing hundreds and thousands of parts into Thane municipality and taking it out of the territory. You link on one-to-one basis. You are not linked, therefore I'll assume everything is beyond 6 months, I'll reject the refund. That was the stand of Thane municipality. That the Supreme Court said you can follow Clayton's rule, you can adjust it first in first out method. So 83 STC is an authority for first in first out method. Clayton's rule can apply for this. Secondly, 45 STC Vijay Oil Mills Kerala High Court went into this question against adjustment of debts itself. It is open to the creditor to adjust 45 STC. Therefore, if you have one invoice of 50 lakhs plus 6 lakhs, next invoice of say 20 lakhs plus 3 lakhs, okay, and the party pays you 52 lakhs, I don't know whether you can say Clayton rules apply, then 2 lakhs will be adjusted against this thing. But open to you to adjust against, need not be in the order. Is it open to you to adjust 50 lakh against the first invoice and 2 lakhs against the 20 lakhs the second invoice? I am not clear on that because problem is a single date. Okay. As the question as to whether when there is single date, because there are not 2 dates against each invoice, 50 one date and 6 lakh another date. I don't see any reason why if party adjusts, the person who tenders the payment doesn't say, why he cannot adjust the way he wants. If that karma caching principle is correct, why he cannot adjust? Plus we are concerned with criminal liability. Okay. So, as far as collects any service tax is concerned, this is all I wanted to say. Invoicing is not enough. Provisional collection is not collection. The section is not retrospective. Offence is taken place on the day it is. And it is open to you. When on account payment, certainly you can adjust it the way you want. It need not be adjusted against the tax portion first. Okay. And when you have more than one debt, possible.
Sir, in case if there is any inquiry or investigation is going on, tax liability is not decided. In that scenario also they can charge, maybe bills are there, quantification is not done.
Quantification is not done means?
Like they have booked a case, preventive has booked a case against the SSE. They have seen some records and all, and on that basis they have concluded that this much amount is exceed of 50 lakhs.
You are collected.
Like our invoices are there,
Right.
and on that basis they have concluded charged.
So what is the, okay, before going to this question which just now is this enough. What's the practical thing? In all these matters, when there is a likelihood of this problem arising about arrest etc., of course you will examine the matter from these legal angles and put in a written representation making out a case how it is not collected by these reasons. Give legal arguments, let it come on record. So that at subsequent stage, if they create trouble, because firstly if you put in a proper this thing, they also are careful about it. Okay. And subsequently we can say there is a serious dispute as to whether I have collected or not. This problem kya hai? This fellow will browbeat the assessee and get a statement recorded. So you must be careful that if you have, because they don't understand this legal principle that easily, the Clayton rule, collected means this thing, on account payment etc. Therefore you must keep a template in your system ready, okay, and modify the template. Don't use the template mechanically. Modify the template, and that representation should go whenever this this oppressive investigation is going on, repeated summons are taking place. That should be, it's not what you need. You should not argue this for the first time before the court or the magistrate. It should be already on record. So that you put in a whether they listen to it, read it, understand it is not your problem. वो कर देना चाहिए. Because that also puts them in the back foot. Now, what's your question you asked, sir?
Like in case of preventive inquiry or like that, without concluding the tax liability, can they arrest on the assumptions, presumptions of? But as you said, that confirmation statement is there of the SSE.
Plus your invoices are also there. And these invoices are not shown as outstanding in your books, then what else is needed? So you are, with your suggestion that there is no assessment. See, if he says, if the section says anybody who has evaded tax beyond 1 crore, we will arrest, which is a mistake they made in the section as it stood prior to 2011 when the Om Prakash judgment of Supreme Court came. They said, how do you know it's more than 1 crore? Till the time assessment is done. If you link your prosecution and arrest with the duty evaded, in a case like customs where gold is found and non-declaration, straight away there can't be a defense about it. Or duty liability is there, straight away there can't. But in a case where assessment is to be done to estimate the liability, okay, then you can say, look, the section won't apply. But here, 89D refers to collection exceeding 50 lakhs. You will certainly take this minimum precaution of showing that invoices were raised for this, and as Rajiv was mentioning, everybody will have more than 50 lakhs nowadays. Nothing much in these things. Okay. So there is nothing for, even without the statement, If you can disprove it only by showing on account payment or more outstanding is there, I have adjusted against principal sum in all the invoices, I have not adjusted against anything towards tax. Okay. And tell him also, there may be deferment of tax under rule 6, okay. But 18 and 1D doesn't apply. Okay. Otherwise, when the invoice is there and amounts are collected, then you will have a difficulty on that. Okay.
Sir, last question, sorry.
No, any question?
What about the liability and the reverse charge?
Will not apply. Certainly not apply. Sorry, I wanted to mention that. Absolutely. No question. Absolutely plain. Every liability is not governed by section 89. There is no complete exhaustion of all situations where liability tax is there. Any collection. In fact, we had section 140A3 Salim Ariyarka's judgment of the Madras High Court. 140A3 self-assessment tax, if you defer, you will be liable for penalty. There is a section. That we Ramaswamy struck down the section, saying where is a question, if there is a delay in payment of tax, you can collect interest, you can never impose penalty. Okay. But that was reversed by the Supreme Court. There again he said, this can never apply to indirect tax. In indirect tax, parties generally collect. We will see that. Okay. Okay. Anything else in this? Anything else in this?
We have 5 more minutes if you have any questions.
Yes, sir.
So this, what knowingly evades the payment of taxes, how loose it can be?
Bhaiya, that is for prosecution, no? That's for criminal lawyers to, don't worry, there will be no arrest on that ground. Knowingly will be matter of this thing. You can certainly find out some circular of the board, some lawyer who would again an opinion, some tribunal single member who have taken a view in your favor in most situations. So that is enough. Is it not? In this country you can trust some judgment taking a view in your favor. Okay. Or some commissioner appeals deciding in some favor. So knowingly evades is very easy to get out, saying that I had a bona fide reason, etc. And that's a matter for trial subsequently. There will not be a ground for arrest. Okay. Chale, aage je. Shall we go to the...
Assess in default.
Huh?
Assess in default. Under the recovery proceeding, assess in default. Service provider tax, they are issuing him notice to me.
I am coming to the next point, sir. That is for recoveries, no?
I am only on this, sir. Because where tax can fall under 89T, because general impression is created. Okay, once this is done, assessing default is in the source of the assessee himself.
No.
That is appears, sir.
So in other words, he is saying if a notice issued to the bank to hand over the money due to the assessee to the tax department, it defaults it. 89 is available. No. Firstly, there is no section unlike our 226 which deems that person to be for these purposes also. None of the clauses will apply.
Because they are trying to untwist the other person.
How to hoga, but that plainly not applicable. So good question. Yeah, Krishnan sir, you want to say something? Okay. Shall we then go to recovery, sir? Sir, you are talking about recovery because he was mentioning that recovery is also practical, this thing. Two distinct things. Recovery during investigation and recovery after the assessment order is passed pending the tribunal application. Okay. Second is purely legal problem. First is both a legal as also a practical problem. Okay. In cases where Assistant Commissioner has passed an order, or Commissioner appeals has passed an order, or Commissioner has passed the order and your application is pending for stay, whether they can affect a recovery. Circular was issued by the CBEC last year, saying that it will affect a recovery. Then the Bombay High Court struck it down. LNT, okay. I told Justice Chandrajud, sir, last year CBDT gave this gift to the industry. This year this gift is for CBEC because in 2012 CBDT came up with a circular which was struck down in the UTI case. UTI case is judgment of Bombay High Court on recovery pending the stay applications, UTI case. That was on direct tax. Then I told him it is there in CBEC in this thing. Okay. Then after the judgment was delivered, the department was feeling that judgment is applicable only for L&T, not for all assessees. Then I mentioned to the court, sir, they are misusing your kindness. Okay. Then he passed a judgment saying that highest administrative authority in Bombay, Maharashtra, is directed to issue administrative guidelines, bringing to the notice of the authorities concerned that this is the law laid down by this court. I don't know whether the Chief Commissioner issued a circular of that kind. If not, Chamber can ask the Chief Commissioner right now, enclosing Ultratech and the second judgment of the Bombay High Court, making it clear that you cannot conveniently misconstrue it, deliberately or conveniently misconstrue it. Okay. So that will solve at least applications, stay application pending before Commissioner appeals, etc. Because in January, February, March, that Chamber should write that. That is one. The more serious problem is now that 360 days or 365 days, the High Court Tribunal took the view somewhat casually that we have the power to extend even after the amendment. And Allahabad High Court has now set aside the tribunal's order and said no, you cannot extend beyond 365 days. I am now told that CBEC met or something under pressure of the minister, etc., etc., to fully utilize the amended section. Okay. The amended section says that beyond 365 days, no stay can be, even if the assessee is not responsible for the delay in disposal of appeal, stay will stand vacated. So you will have string of cases based on this. One is stay application is pending, that is okay, that is taken care of. Secondly, tribunal extends 6 months, they automatically extends also. But third is beyond 365 days, they are now in the process of, and they will have series of cases in this week itself. Because yesterday I got a call from ONGC saying they attached the bank account saying 365 days are over, tribunal has extended the stay till the disposal of appeal. The problem is, Allahabad High Court had taken a view that in view of 365 days, tribunal cannot grant stay. Karnataka High Court in some case in income tax after the 2008 amendment also taken that view. You all must be aware of it. I am told Ecom Gill Coffee Trading Company. Ecom Gill Coffee Trading Company. Karnataka High Court took the view that no, after 365 days, even if the assessee is not responsible for the non-disposal appeal, stay stands vacant, recovery can lie. And Karnataka High Court declined to follow the Bombay High Court judgment in Narang's case. Narang overseas, the sequence is, there is a judgment of Justice Rebello and Devdar in Narang overseas saying, and that was pre-2008 income tax section 254(2)A, saying that the tribal does have the power to extend it beyond 6 months. Okay. Then the Bombay High Court followed it in Ronak 2011 333 ITR 99. Post 2008 also. Why I am referring to this is, somebody should say Narang overseas is 2007 section of 254(2)A, and 2008 we have made an amendment expressly saying notwithstanding there is no fault of the assessee. So 2011 333 ITR 99 Ronak, Bombay High Court follows Narang after 2008 also. Okay. Karnataka High Court has not agreed with this. But at least as far as in Bombay is concerned, we can insist on this. Second, any case since these are likely to be the spate of disputes in the next couple of weeks, you all must move the High Court challenging this section if a problem arises and say that in view of Narang and this thing, this section should be struck down. And point out how the tribunal is not able to dispose of appeal for next 10 years, 15 years, etc. Okay. In case we are moving a writ in ONGC, if the section is struck down or stayed, that will solve the problem.
Can you make a fresh application for the waiver of treaty policy?
That's what we are discussing, sir. You may make, but High Court, Allahabad High Court says you have no power. Karnataka High Court said you have no power. Bombay High Court says you have the power. Okay. But there is no purpose in, because tribunal will say we are bound by Allahabad High Court in excise itself. Okay. So you are in for some, complicated, pressure days in the next couple of months because of this issue.
They are not, sir, they are not, sir, extending it. I am taking a fresh step.
Makes no difference beyond 365 days. That's the contention we are raising, but Allahabad said no. Okay. Any case, this is the stand revenue has taken and they are implementing it seriously. Okay. So this will happen this. So आप जो बोल रहे थे ना stay application is pending, वो तो पुरानी बात होगी. The current problem is this. Okay. Second. What's the other one on recovery, sir? The last part on recovery is your bank account attachment, etc. Okay. I am told the practice followed here is get a statement record from assessee that I am liable to pay. If it is a case of collection and not remit, is a different matter. That is under 73A. In case they will say they will accept, they will get a statement from the director saying it is liable. He has not paid it. Therefore, the right to the bank. In statement dated so and so, director of the company has accepted, he is liable. Therefore, I request you to freeze the account. Okay. This matter is under challenge in the High Court. We say there is no question, even if he has admitted. Admission is only a piece of evidence. Okay. Which can be used during adjudication proceedings. That is not a substitution for adjudication. So that matter is to be argued out. The matter will be over in about 2 weeks' time. So, cases where you are not collected but you are admitted during investigation, as of now the writing to the bank and customers, but that problem should get resolved in 2 weeks' time. Either way the court will say they have the power, they can circumvent every provision of law, or they will say not possible. Okay. That part is over on this. I was told, I had a curious case. One state bank general manager met me saying, sir, my job is at stake because the service tax fellow wrote to the bank manager attaching the accounts. Okay. Even after our letter and acknowledging it, you predated and allowed the party to withdraw money from the account or something, and therefore disciplinary action may be taken against him. When you now go to the bank, there is no money. Disciplinary action may be taken against him. Garke, the service tax department wrote to the State Bank of India. That's also a government. Immediately fix responsibility, take necessary action. Karke, wo hamare paas aaya tha. Then I asked him casually, is it a OD account or what? A cash credit account? He said, yes sir, overdraft account. Saru sir, overdraft account. They want to, if the manager continues to allow the associate to operate the account in the overdraft account, there is no breach, there is no attachment possible of an overdraft account. Okay. That the Bombay High Court has taken a view. There is a judgment in sales tax itself, but I am not able to get it in this thing. I will try and get you that. This is in Sargam Foods. There is a state of Maharashtra. Writ petition number is, it might have been reported, I don't know. Writ petition number 4313 of 2008. Dated on 8th July 2010. So as far as OD accounts are concerned, there is no problem. Okay. But if they write to customers, okay, and say they don't make payment to them to me, then there is a problem. That garnish proceedings. Okay. Unlike income tax where that man says I have owed nothing to him, if he states a no such provision is there. And the Mahindra and Mahindra man telephoned me, sir, this is too much, sir. The service tax department writes a letter to me that you are such and such fellow is in arrears, you owe him some money, you please pay that to me. So it first goes to accounts department, etc., etc., etc. By the time it lands in the excise department, service tax department, the computer would have already generated money and paid that fellow. What happens, sir? I said, you are in trouble. You are in absolute trouble. There is no. Okay. After the letter is served on you, your internal coordination, you would have computer would have pre-programmed it. All vendor payments will be released on 60th day. So automatically it will be released. So you are in trouble. Plus, may not happen in practice. I am sure service tax department doesn't write back to all the people whom they garnish notice. Now I received money equal to the arrears. Okay, you garnish notice withdrawn. Kabhi nahi karte. They write to all customers for same 10 lakhs There is no record of who has paid, who has not paid. There is no garnishing notices themselves do not communicate with each other. It's a mess in the section. The courts have said this should be used sparingly and rarely because of these problems. Okay. Our fellows, even without waiting for an adjudication, resort to this power. Okay. Legally, garnish notice issued. If that fellow makes a payment to the party instead of service tax department, he is in difficulty. Okay. He has to challenge the garnish notice, particularly prior to the, because after the order is passed, he will be governed with a stay order. Prior to the order, you have to file a writ and get that order. Okay. Thank you very much, sir. Anything else?
One question on the garnish, sir. Allow me. Sir, before the due date, can it be applied? For example, I have a credit period of 3 months from the creditors. So now, in my book,
Credit period means
I have 1 crore to pay to him.
to the defaulting assessee.
Yeah.
So you are Mahindra and Mahindra. You have to pay 1 lakh to Rajiv, who is a tax
I
evader.
pay 1 crore rupees, sir.
Right.
1 crore rupees. And that 1 crore rupees, as per my terms of the purchase order or a contract, is not due as on date.
Ah.
It is due, suppose after the March 2014.
Yeah.
Is it due only or something simply is lying by credit? Account the credit. The garnish you operate, sir.
Whenever you make payment to him, instead of making payment to him, you will pay to him. That's all.
After it is due date, no, sir?
Absolutely.
After it is paid. That is what
Just what I think. I have not seen that section.
they don't understand that.
Anything else, sir? Thank you. Thank you very much.
Friends, I have been allotted the pleasant task of proposing vote of thanks. You know, we, after this voluntary encouragement scheme, we are seeing all these advertisements in the TV and all those things, where the driver is teased by other fellows. Okay, your owner is not paying service tax and all those things. And even the reports in the show many papers where the stern action will be taken against the tax evaders. So I think most of us, even myself, we are chartered accountants, we have never seen a person behind bar. So if we see the person that where it is a non-bailable and the person is put behind bar, say on Friday, तो Monday ही बाहर आएगा. Now with the expertise of Mr. Sridharan and the practical approach he has said to be taken, he has given the knowledge to us whereby we can build out our clan in such cases. I therefore request all of you to carry a loud vote of applause for such a wonderful lecture here. Now we are immediately starting with the third and the last paper on the case studies under the service tax, excluding Senved credit and composite transaction by CA Parin Mehta. Thank you very much.